Welcome back to our fourth lecture on torts in our business law course. We're still broadcasting from the Hawaiian Airlines broadcasting booth at the studios of WCLG. I want to report that it's still a balmy 81 degrees in Lahaina, and you may be hearing some of the tropical birds in the background, which lends sort of an air of really tropical niceness to our series of lectures. Today we're going to talk about negligence. It really is the biggest area of torts. Now, one of the things that you find is that negligence is where most of your contingency fees are found. Remember, we talked about contingency fees. Those are the fees that a client agrees to pay to a lawyer if the client and the lawyer win their case. If they don't win, then the client doesn't owe any fees. Once in a while they owe costs, but not all the time. But contingency fees are in negligence cases. And why is that? Well, number one, negligence cases tend to have large awards, so it attracts lawyers who are interested in getting the bigger fee because they have put in a lot of work and want the fees for that case. The second thing is that negligence cases are almost always defended by insurance companies. And insurance companies have deep pockets, so they can, in fact, pay those fees. Now, if an insurance company came after me or you, so what? I mean, so if a plaintiff came after me and you, none of us would be able to pay huge fees like the insurance companies would. And even if we could pay them, they'd play hell getting them out of us. So anyway, the insurance companies are attractive targets and are often, and that's the reason anyway, that negligence is one of the areas where contingency fees are found. I would like to just add a footnote here that you never see contingency fees in criminal cases. Criminal cases don't have awards, and so the lawyers making the defense don't get the possibility of any sort of contingency fee. So just keep that in mind. Now, what are the elements of negligence? First, defendant owes a duty to plaintiff. Now remember, the delta sign is for defendant and the pi sign is for plaintiff. Two, there is a breach of that duty. That's supposed to be a D, by the defendant. Three, there's causation. And that causation from the breach causes a damage to the plaintiff. Now remember, you've got to have all of these elements. You must have one, the duty, plus the breach, plus the causation, plus the damages to the plaintiff. So that is the negligence equation, folks. Negligence equals duty plus breach plus causation plus damage. If you don't have each of those elements, each of those four elements, you will not have negligence, and you must have them all. Now I want to tell you something. Causation is made up of two types. One is the causation of cause and fact. Now, what is cause and fact? Cause and fact just means that something happened that caused something else. God created the world, so therefore plaintiff X was hurt in a car accident. Ford Motor Company made a pickup truck that hurt the plaintiff. So-and-so's fire embers came out of their chimney and caused a forest fire. That's causation in fact. It is a really broad kind of thing. And anything in the whole wide world could be a cause in fact. That's too broad for the law. The second kind of causation is proximate cause. Okay? Proximate cause. Proximate cause is defined as what kind of damage is foreseeable. From the acts of plaintiff. From the defendant, acts of the defendant. So, there's two kinds of causes. Cause in fact, it's the really broad kind of thing. For example, God created the world, therefore the accident happened. Too broad. Proximate cause is the foreseeability of the harm caused by defendant's actions. Now, proximate cause comes from a case called Paul's graph, G-A-P-H, versus, no, I think that's an F, versus the Long Island Railroad. Now I'm going to take a bit of time here for some artistic license and tell you what happened in that case. Helen Paul's graph was on a train platform waiting for a train. Across the station, there was a man hurrying to catch a ride on a train. He was a portly gentleman, and he was carrying an unmarked bag. He tried to make the train, and almost did, but when a guard inside grabbed him and pulled him onto the train, and a guard outside pushed him onto the train, so he made it, but he dropped the bag. In the bag was a bunch of fireworks. They exploded when they hit the ground and the tracks, and the explosion apparently caused a set of weights on the other side of a weighing station, or like a scale or something, fell onto Helen Paul's graph and injured her. Helen sued the Long Island Railroad for damages, saying that the railroad was negligent in helping the man aboard the train, causing the fireworks to fall, causing the fireworks to explode, causing the scales to fall on her. In an opinion that is quoted to this day, in the case of Paul's graph versus the Long Island Railroad, the court said no, the railroad was not at risk. Why? Because the damages to Helen Paul's graph were not foreseeable from the actions of the railroad and its guards. It is not foreseeable that scales will fall on somebody across the platform by the guards helping the man onto the train. And you've got to remember the test of negligence is not just cause and fact, but proximate cause. And the test of proximate cause, the test of proximate cause is foreseeability. You've got to remember that. Now, next time we will continue with our lectures on torts. Thank you.